In this segment, we'll talk about Chapter 11 disclosure statements. You may have seen our other segment on Chapter 11 or know that in the Chapter 11 reorganization bankruptcy, the result is hoped to be a plan of reorganization that lays out the new deal, the new contract for creditors. It explains who gets paid, when, and how. Before the court will consider a plan of reorganization and allow creditors to vote on it, the court will approve a disclosure statement that explains the plan. It allows creditors to make an intelligent decision, and it is supposed to contain adequate information to permit that. When a plan is filed, the debtor, the bankrupt, proposes a disclosure statement also. That's followed by a notice and a hearing before anyone gets to vote on the plan. It may take some time to get the disclosure statement approved. There may be objections. Creditors or other parties in interest may oppose the approval for strategic reasons. And so that might take months before a disclosure statement is approved. And again, the plan can't be voted on until a disclosure statement is approved. Ironically, the people who generally know most about the debtor and its bankruptcy are the ones who are fighting the disclosure statement, and as I said, it's often for strategic reasons. Once the disclosure statement is approved, it and the plan are sent to creditors with a ballot. There may also be a document called a plan summary, which summarizes the plan further. All of this is to allow the creditors to make an intelligent decision on the plan so that they can decide whether or not to vote for it or vote against it. In summary, when the court is considering a plan of reorganization in a Chapter 11, before the creditors are permitted to vote on it, the court must approve a disclosure statement to be sent to the creditors.
In Chapter 11 bankruptcy cases, the plan of reorganization lays out who gets paid, when, and how. Before the plan can be approved, the court must first approve a disclosure statement that explains the plan to creditors. There will be notice and a hearing on approval of the statement. This approval process may take some time, as it may be used by those that oppose the plan as a way to interfere with it moving forward. After the disclosure statement is approved, it's sent to all creditors with the plan of reorganization and a ballot so that the court can move forward with considering the approval of the plan. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.